'tis the season to speak of treason, right? You know? So I figured we'd start talking about banking a little bit. A lot of people are just out there lost. First of all, if you want to understand negotiable instruments and dishonor and all that good jazz and remaining in honor as far as banking is concerned, or the commercial application, you might want to start studying the UCC, okay? We're going to go into some ultra-virus banking laws and the U.S. Supreme Courts and other courts that upheld what I've been saying for years and years and years and years, okay? When you're looking at a mortgage, if the note and the mortgage are separated, they're a nullity, they're void in abitio from the beginning. You've got the credit swap default agreement, which is when the bank sells the note to somebody else and then the loan falls through or somebody defaults on it, then the one who sold it has to buy it back. Typically they have a different LLC set up to buy it back. And then you have your, I always struggle with this one and I don't know why, because it's so flippin' simple. The retail installment agreements, okay? Then you got the UCC one and on and on and on. But for now, we're just going to cover banking with some court cases that you can lean upon, all right? The United States Code, Title 12 again is banking. Section 24, paragraph 7, confers upon a bank the power to lend its money, not its credit. In First National Bank, Tallapoosa versus Monroe, 135, Georgia, 614, 69 S period E period 1123, 1911. The court, after citing the statute heretofore said, the provisions referred to do not give power to a national bank to guarantee the payment of the obligation of others solely for their benefit, nor is there any authority to issue them through such power incidental of the business of banking. A bank can lend its money, not its credit. Meanwhile, they do it anyway for a profit motive, even though it flies in the face of their primary duty to protect people's money. In Howard and Foster Co. versus Citizens National Bank of Union, 133 S period C period 202, 130 SE 758. This case was had in 1927. It was stated, it has been settled beyond controversy that a national bank under federal law, being limited in its power and capacity, cannot lend its credit by guaranteeing the debt of another. All such contracts being entered into by its officers are ultra-virus and not being binding upon the corporation. An activity constitutes an incidental power if it is closely related to an express power and is useful in carrying out the business of banking. See First National Bank of Eastern Arkansas versus Taylor, 907 F period 2D 775. But even with the latitude, no hint of lending credit is provided in Title 12 USC subsection 24 that would give rise to an incidental power to lend credit. The exercise of power not expressly granted to national banks is forever prohibited. First National Bank versus National Exchange Bank, 29 U.S. 122, 128. California versus Kennedy, 167 U.S. 362, 367. And Concord Bank versus Hopkins, 174 U.S. 364. Further, it is laid down as a general rule that a national bank cannot lend its credit by becoming surety, endorser, or grantor for another. In the federal courts, it is well settled that a national bank has not power to lend its credit to another by becoming surety, endorser, or grantor for himself. See the following cases. C.E. Haley and Sons versus Stewartson National Bank, 1NE2D 858, 285, III, appellate level 290. People's National Bank of Winston-Salem versus Southern States Finance Co., 122, S period, E period, 415, 192, N period, C period, 69, 48, ALR 519. Cooley versus Chowchilla National Bank, CHOWCHILLA National Bank, 255 P 188 200 C period 760 52 ALR 569. Rice and Hutchinson Atlantico versus Commercial National Bank of Macon, MACON, 88 S period E period 999 18 Georgia Appellate Court 151. First National Bank of Hagerman versus Stringfield, 235 page 897 40 III Appellate Court 376. City National Bank of Wellington versus Morgan, Civil Appellate 258 S period W period 572, and Farmers and Merchant Bank of Reedsville versus Kingwood National Bank, 101 S period E period 734 85 W period VA Virginia 371. And the last one finally, Best versus State Bank of Bruce, 221 N period W period 379 197 Wisconsin 20. A national bank's charter requires that they protect customers' money first and then make money second. National banks are only allowed to make money in order to protect people's money, so one serves the other. But the priority is to protect. In Central Transportation Co. versus Pullman, 139 U.S. 60 11 S period CT period 478 35 L period ED period 55, the court said, a contract ultra various being unlawful and void not because it is in itself immoral, but because a corporation by the law of its creation is incapable of making it. The courts, while refusing to maintain any action upon an unlawful contract, have always striven to do justice between the parties, so far as could be done consistently with adherence to law. By permitting a property or money parted with on the faith of an unlawful contract to be recovered back or compensation to be made for it. In such case, however, the action is not maintained upon an unlawful contract nor according to its terms, but on an implied contract of the defendant to return, or failing to do that, to make compensation for property or money which has no right to retain. To maintain such an action is not to affirm, but to disaffirm the unlawful contract. A. When a contract is once declared ultra vires, the fact that it is executed does not validate it, nor can it be ratified so as to make it the basis of suitor action, nor does the doctrine of estoppel apply. Fand PR versus Richmond. And B. A national bank cannot lend its credit to another by becoming surety, endorser, or grantor for him. Such an act is ultra vires. Merchant Bank versus Baird, BAIRD, 160 F 642. The following case sites are also support this memorandum on credit loans and void contracts. In the federal courts, it is well established that a national bank has no power to lend its credit to another by becoming surety, endorser, or grantor for him. Farmers and Miners Bank versus Bluefield National Bank, 11 F 2D 83 271 US 669. A national bank has no power to lend its credit to any person or corporation. Bowen versus Needless National Bank, 94 F 925 63 CCA 553. Soterio denied and I'm not sure I'm pronouncing that right. Sotoria, CERTIORARI, denied in 20 S period CT 1024 176 US 682 44 LED 673. Mr. Justice Marshall said the doctrine of ultra vires is a most powerful weapon to keep private corporations within their legitimate spheres and to punish them for violations of their corporate charters, and it probably is not invoked too often. Zinc Co. versus First National Bank, 103 Wisconsin 12579 NW 229. American Express Co. versus Citizen State Bank, 194 NW 430. A bank may not lend its credit to another even though such a transaction turns out to have been a benefit to the bank. And in support of this, a list of cases might be cited, which would like a catalog of ships, emphasis added. Norton Grocery Co. versus People's National Bank, 144 SE 505, 151 Virginia 195. It has been settled beyond controversy that national banks, under federal law, being limited in its power and capacity, cannot lend its credit by guaranteeing the debts of another. All such contracts entered into by its officers are ultra vires. Howard and Foster's Co. versus Citizens National Bank of Union, 133 SC 202 130 SE 759. This case was had in 1926. Checks, drafts, money orders, and banknotes are not lawful money of the United States. State versus Nealon, 73 Pac 324 43, Oregon 168. Neither is included in its power, not incidental to them. It is a part of a bank's business to lend its credit. If a bank could lend its credit as well as its money, it might, if it received compensation and was careful to put its name only to solid paper, make a great deal more than any lawful interest on its money would amount to. If not careful, the power would be the mother of panic. Indeed, lending credit is the exact opposite of lending money, which is the real business of bank. For while the latter creates a liability in favor of the bank, the former gives rise to a liability of the bank to another. Morris Bank and Banking, 5th edition, section 65, McGee Banks and Banking, 3rd edition, section 248, American Express Co. versus Citizen State Bank, 194 NW 429. It is not within those statutory powers for a national bank, even though solvent, to lend its credit to another in any of the various ways in which that might be done. Federal Intermediate Credit Bank versus Lee Harrison, or L. Harrison, 33F2D 841 842 1929. There is no doubt but what the law is that National Bank cannot lend its credit or become an accommodation endorser. National Bank of Commerce versus Atkins, 55E 471. The bank is allowed to hold money upon personal security, but it must be money that it loans, not its credit. Seligman versus Charlottesville National Bank, 3 Hughes 647, Fed case number 12642, 1039. A loan may be defined as a delivery by one party to and the receipt by another party of a sum of money upon an agreement expressed or implied to repay the sum with or without interest. Parsons versus Fox, 179 GA 605, 176 SE 644. Also see Kirkland versus Bailey, 155 SE 2D 701, and United States versus Neffert, White Co. 247, Fed Superior Court, 878, 879. The word money, in its usual and ordinary exception, means gold, silver, or paper money used as a circulation medium of exchange. Lane versus Riley, 280 Kentucky, 319, 133 SW2D 75. A promise to pay cannot be A promise to pay cannot, by argument, however ingenious, be made the equivalent of actual payment. Christensen versus Beebe, 91P 133, 32 Utah 406. A bank is not the holder in due course upon merely crediting the depositor's account. Bankers Trust versus Nagler, 229 New York State 2D 142 143. A check is merely an order on a bank to pay money. Young versus Humbry, 73 P2D 393. Any false representation of material facts made with knowledge of falsity and with intent that it shall be acted on by another is entering into contract, and which is so acted upon constitutes fraud and entitles party deceived to avoid contract or recover damages. Barnsdale Refining Corn versus Burnham Wood Oil Code 92F period 26817. Any conduct capable of being turned into a statement of fact is representation. There is no distinction between misrepresentation affected by words and misrepresentation affected by other acts. Leonard versus Springer, 197 III 532 64 NE 301. If any part of the consideration for a promise be illegal, or if there are several considerations for an unservable promise, one of which is illegal, the promise, whether written or oral, is wholly void, as it is impossible to say what part of which one of the considerations induced the promise. Menominee River Co. versus Augusta Spies, L and C Co. 147 Wisconsin, 559 period 572, 132 NW 1122. The contract is void if it is only in part connected with the illegal transaction and the promise signer, promise single or entire. Guardian Agency versus Guardian Mutual Savings Bank, 227 Wisconsin, 550 279 NW 83. It is not necessary for rescission of a contract that the party making the misrepresentation should have known that it was false, but recovery is allowed even though misrepresentation is innocently made, because it would be unjust to allow one who made false representation, even innocently, to retain the fruits of a bargain induced by such representation. Whip versus Iverson, 43 Wisconsin, 2D 166. Federal Deposit Insurance Corporation versus Turner, 869 F2D 270, Sixth Circuit Court, 1989. Turner was told that the bank for the debtor's name would be completed by adding the name of a company affiliated with Turner. Unknown to Turner, the guarantee was completed by filling in the name of the debtor with whom Turner was not affiliated, and by altering the guarantee to change the name of the bank creditor. The court held that Turner could assert a fraud claim against the Federal Deposit Insurance Corporation as owner of the note in its corporate capacity. Southern Mortgage Company versus Odom, 699 F Superior Court, 1227 S period D period Mississippi, 1988. The court held that the fraud claim was defective since it alleged a promise to perform an act in the future or a representation as to future events. The court rejected this claim, holding that there was no evidence that the lender had any sort of power or dominion over the borrower, who was free to seek financing elsewhere. American National Bank and Trust Company versus Hanson Construction Co., Inc., 1991, WL 42668, Kentucky, 1991. The court held that considering the relationship of the parties, Hanson was reasonable in relying upon the alleged representation by the bank. The court held that the future financing provisions were not so identified that it would be unreasonable for Hanson to rely upon them. Hanson's failure to read the loan documents was excusable since he was encouraged by the bank officer not to read them, and the bank officer advised him not to have his lawyer present at the closing. The court affirmed a jury award of compensatory and punitive damages against the bank. Nibby Brothers Incorporated versus Brannan Street Investors, 205 California Appellate Court 3D 1415, 1988. The court acknowledged that the statute would not bar a claim for unjust enrichment if it could be shown that the benefit had been conferred on the lender by mistake, fraud, coercion, or request. Thus, had Home induced Nibby to provide work on the project under circumstances in which Home's inducement fell under circumstances traditional categories of mistake, fraud, coercion, or request, a claim for unjust enrichment might escape the reach of the statutory bar. Bank of Sun Prairie versus Esser, 151 Wisconsin 2D 11, 442, N period W period 2D 540, 1989. The court affirmed the jury verdict in favor of Esser for fraud based on evidence that at the closing, the bank advised Esser that she was signing only for the new truck loan. The court held that Esser's reliance on the bank's misrepresentation was reasonable since she trusted the bank's security practices and believed that the guarantee only applied to the new loan. The court also held that the trial court should have submitted Esser's punitive damage claim to the jury because of the evidence that the bank's misrepresentation was active and the bank took advantage of Esser's trust and reliance. Touche Ross Limited versus Philippek, 778 P2D 721 HAW 1989. The court held that the alleged misrepresentation made by the bank were material and actionable since it was claimed that the bank affiliate did not have the development The bank did not have the development expertise it was represented to have and had no intentions of advancing the funds when the promise was made. Blankenheim versus E.F. Hutton and Company, Inc., 217 California Appellate Level 3D 1463. The case happened in 1990. The court held that a claim of negligent misrepresentation is included within the definition of fraud as used in the statute, and as the term is defined in Civil Code subsection 1572, the court also held that the question of fact were presented as to whether the investor had justifiably relied upon Hudson's alleged representation concerning the investment. First National Bank of Montgomery versus Jerome Daly, regarding the power to delegate the control of our money supply to a private corporation can be found in 16 Am Jurisprudence 2D section 347, which states, the rule has become fixed that the legislator may not delegate legislative function to private persons or groups or to private corporations or a group of private corporations. Bank association, from the very nature of their business, are prohibited from lending credit. St. Louis Savings Bank versus Parmalee, 95 U.S. 557. Banking corporations cannot lend credit. First National Bank of Amarillo versus Slatone Independent School District, Texas Civil Appellate Court, 1933, 58 SW 2D 870. Nowhere is the express authority granted to a corporation to lend its credit. Gardiner Trust versus Augusta Trust, 134 ME 191 291 US 245. A national bank has no authority to lend its credit. Johnston versus Charlestonville Bank, CCVA, 1879, Fed case 7425. A contract made by a corporation beyond the scope of the corporate powers is unlawful and void. McCormick versus Market National Bank, 165 U.S. 538. Note, Black's Law Dictionary, ultravirus, Latin for beyond powers, it refers to conduct by a corporation or its officers that exceeds the powers granted by the law. Despite the above court cases, Ralph Gelder, Superintendent Department of Banks and Banking, State of Maine, said on February 20th, 1974, a commercial bank is able to make a loan by simply creating a new demand deposit, so-called checkbook money, through bookkeeping entries. This is in total contradiction to what the courts have said, yet that is exactly how the banks create the money to loan to its customers or to buy government bonds. Act is ultravirus when corporations is without authority to perform it under any circumstances or of any purpose. By doctrine of ultravirus, a contract made by a corporation beyond the scope of its corporate powers is unlawful. Community Fed S&L versus Fields, 128 F2 ND 705. A holder who does not give value cannot qualify as a holder in due course. Uniform Commercial Code, subsection 3-303.1. In securities law, the most important requirement is full disclosure. Investors have to be given the full scoop. You cannot hold anything back. Everything, lawsuits, criminal records, market shares, debt has to be disclosed. This same type of disclosure is required in the Truth in Lending Act, TILA, as well. With that said, why is it that no one has ever heard of this legal argument? Well, probably because they have not been told. But don't you think that it is important and relevant to tell potential loan customers as well as bank shareholders that according to the U.S. Code and numerous judicial decisions, it is questionable whether a national bank is actually authorized to lend credit, become a grantor, or become surety? They should at least say something to their customers and shareholders along the lines of this. Disclaimer: we, the bank, are lending credit, guaranteeing debts, and becoming surety through our lending business for profit. The Comptroller of the Currency approves. Congress has been silent in recent years. However, both federal and state courts in the past have repeatedly told us that the National Bank Act does not provide for this activity. Therefore, at any point in the future, the bank could be subject to either federal or state cease and desist orders. In that event, the bank will require immediate and full payments and will cancel your credit or loan. Further, the bank will be exposed to civil lawsuits for all its former loan clients and shareholders. Here are the other things to consider. If a party breaches its authority by entering into an agreement that it knows it is not allowed by law to execute, is it moral to allow that party to enforce the agreement? Is it moral to force a person to pay a loan when that person did not know that the bank did not have the legal authority to issue credit or to become surety? Is it moral for a bank to place a negative mark on your credit report when they did not have the authority to enter into an agreement in the first place, and that any deficit in payment has been insured by a third-party insurance company and can be written off as a claim? In addition to these 3 points, consider also the moral arguments, arguments based in equity versus legal arguments. Arguments based in law are only upheld if the party seeking to enforce the agreement comes into the court with clean hands. This concept is known as the clean hands doctrine. What this doctrine means is that if a bank desires to enforce an agreement based upon equity morality, then they must have acted equitable, moral. In the case of credit, if the bank knows that the law prevents them from loaning credit, there is over 100 years of case law on this point, and they do it anyway, then they simply do not have clean hands and cannot argue their case in equity. Therefore, they must argue in law. Meanwhile, the law prevents them from loaning credit. There are penalties and forfeitures attached to what the bank did. In this case, there are penalties attached to national banks going beyond their express power in that they are exposing depositors' monies to loss in contradiction to the bank's primary duty, which is to protect. Therefore, the issue that can be raised is the argument of ultra vires, and not only is the contract void, but even if the borrower did receive a benefit, the borrower has not unjustly enriched. If the contract is void, then both parties walk away as if there never was a contract. The judge is then asked to declare a zero balance and deem it as paid as agreed. Since the borrower provided the value for the source of funds, the borrower is also entitled to a judgment in the amount of the highest credit limit issued or loan amount. Also, since the bank acts demonstrates that the bank took unfair advantage of the borrower, this results in the bank needing to be penalized. Typically, the borrower is entitled to ask for a financial award against the bank in the amount of the debt forgiven. Since fraud is committed, the borrower is entitled to all sums paid on the contract, including interest, plus triple damages, attorney's fees expended, and court and other costs in addition. The borrower can also demand a zero balance on this debit. and a voidance of a loan agreement, and a financial judgment in favor of the borrower due to the bad behavior of the lender. We'll come back, we'll talk about additional borrowers relief.